an apology to Tim, because some of what I'm going to be doing is going to sound like Constitution 101 for commerce students, because it's Constitution 101 for commerce students. But what I'd like to do is I'm going to try and draw a very specific use example for what I've called implants, but I probably should have called insertables. I'm going to disagree with Sharon. I'm going to say that dog tags are potentially replaceable in a military environment. And the reason for choosing dog tags as an implant is that it doesn't have some of the issues of active devices. So I'm going to go for a very specific use case, the implantation of RFID devices. And I'm going to try and provide the military view of this in the context of Australian law and rights. So I'm going to run through some of the issues about rights in Australia and perhaps the absence of rights. And I know this isn't going to be terribly, sit comfortably with international humanitarian law scholars, but I'm going to argue that perhaps international humanitarian law also has limited influence on Australian rights. I'm going to have a look at vaccinations, and a number of people have talked about vaccinations, and I'm going to start off by talking about vaccinations not in a military context, but in the context of what those of you who have children have to do with your children. I'm then going to have a quick look at military law in Australia. And part of the reason for doing that is that the Australian tradition of military law, but much more importantly, the Constitution and the way that the military is established and the ability for the military to deal with discipline through tribunals is established, and the separate establishment of the court system means that enforcement is slightly different in the Australian military environment to the Canadian system, and different again from the US system. And in particular, I'm then going to try and answer the question, what is an order? Now, for those of you who take an orders, you know exactly what an order is, but I think it's useful to actually get to what's the basis of an order? What's the actual law that says, well, you're a member of the service that says you have to actually accept that order. And then I'm going to talk about some risks. But first, I'm going to try and provide a link to Donna's piece. So I have a picture here of two cats. They are not Schrodinger's cats. The Schrodinger cat experiment, which was a thought experiment which was on quantum physics, said essentially there's a cat in the box. You know that it's alive. You don't know whether it's alive or dead, but if you open the box, it's definitely dead. Mine are. They're both alive. Interestingly, they've both been vaccinated and they've both been microchipped. Why? Well, I live in New South Wales and I live in Sydney. I live in Glebe, which is part of the city of Sydney. Now, if I have a domestic animal in Sydney, I have to actually register it. I don't have to pay a cat licence fee, but I do have to register my cat. Both of them, top one first and the other one a couple of years later. They're cute, aren't they?
They're beautiful.
Once I've registered my cat, I actually have to provide two pieces of additional information. So I have to provide some information on me, who I am, my address. I have to provide their microchip number, and I have to provide a vaccination certificate. So I can choose to have non-compliant cats. Those are cats that are not registered, they don't have an RFID device in them, and they're not vaccinated. But in practice, I choose to have a vaccinated and microchipped cat, or at least two vaccinated and microchipped cats. And that is simply to be compliant with not Commonwealth federal law, not state law, but by the regulations imposed upon me by my local authority. Level of law, a level of jurisdiction and policy making which isn't even properly recognised in the Constitution. I didn't worry about having my cats microchipped because I didn't actually think there was any great risk. And in coming to think about this particular topic, I had a look at some of the issues that come to the risks of microchipping in animals. I thought I might do that first because pretty much most companion animals in New South Wales are microchipped, and whether they're cats or whether they're cattle dogs, as Kayla mentioned, and the level of harm from microchipping appears to be very low. I did find a paper from the US that reported masses associated with the implantation of RFID devices, and it found in a national survey 2 dogs and a 14-year-old domestic short-haired cat that had masses associated with implants of RFID devices. That sort of implies a very low level of risk, because if you were writing a paper on risks and you can show 3 animals that demonstrate a risk, it actually looks like a bit of a de minimis argument. Why am I looking at dog tags? Well, dog tags are simple devices that actually simply hold some information. They are generally, the ones on the left are Australian-style military army dog tags. The one on the right is a Canadian one. They tend to carry similar bits of information. Australia and Canada identifies the country. So we have AS for Australia, occasionally AU, not actually normalised to the relevant ISO, International Standardisation Organisation coding, and you can see the Canadian one, say CDN forces for Canada. Dog tags have information which is generally some sort of identification number, there's more than an ID number. In the US it used to be up until last year the Social Security number, but as part of improving privacy of information and information security, that's now in the process of being changed to a military identification number. It contains a name. Now, Australia and Canada, it's an initial and a surname. The US tends to have first name, middle initial and surname. It has an important piece of information as to a person's religion. So the one on the left you can see ANG, Anglican. The one on the right you can see LDS, the Church of Latter-day Saints. So religious information has historically been held on dog tags. And the last piece of information is the blood group type. So O positive on both of the left-hand ones, and O positive on the top of the Canadian tag. Why only the top? Why do they come in pairs? Well, sadly, the reason is that one of the tags can be taken from somebody who dies in service. One tag is left with the body, and one is taken as essentially to help record losses. The Canadian one is a break-apart approach. The Australian one, like the US and the UK, is one of the tags is taken, the other is left with the body. Very few bytes of information stored on a dog tag, and therefore potentially one that could be stored on an RFID device. So I know Sharon didn't like the idea of RFID devices replacing dog tags because you might lose a hand. It really depends where the implant is. If the implantation is closer to the neck, that's the same risk of loss as a pair of dog tags. And I've chosen something this simple because I thought it might be useful, as I say, just to have this one use case which is simple. Now, I then wanted to have a quick look at, well, what are the rights? So what would the rights be for a service person to say, I don't actually want an implant. I'm not going to go as far as saying I don't actually want dog tags, but I don't want an implant. And so the first thing to do, of course, is to have a look at, well, what are the human rights that the person would have regardless of whether they work for the military or not. And unlike the US with its Bill of Rights, or most other common law countries like Canada, like the US, there is no Human Rights Act. So essentially, the sources of rights come through from three different sources. The Constitution, and I'll go through, there are some explicit rights set out in the Constitution. They're a bit limited, but they're there. Potentially, and this is where international humanitarian law works, the Commonwealth's external affairs power, that is, by making a treaty, potentially the Commonwealth can bind the state to that treaty and to the rights under that treaty. Common law, and this is so judge-made law, and statute law. Now, unlike some countries, the way that Australia deals with treaties is not to incorporate treaties verbatim into law. There is, in general, you don't say, oh, well, here's the China-Australia Free Trade Agreement, it's now a piece of legislation. Instead, various pieces of legislation are either introduced or amended to give effect to the treaty. So, for example, a result of the US-Australia Free Trade Agreement, using trade as a basis for treaties because it actually gives good examples of how it's done, required an amendment to the Copyright Act. So the Copyright Act gets amended, it gives effect to the treaty provisions. Can you say, oh, well, that's Treaty Clause, Chapter 11, Clause 3, can you say, well, where does that match? You can go through the DFAT website, you can sometimes work out that, but it's not necessarily directly referred to. So what are the constitutional issues? Well, we've got some express rights. We do have a right of freedom of religion. We have the right to vote in Commonwealth elections, although actually that's not quite a perfect right. It says that if you've got the right to vote in a state election, you have a right to vote in a Commonwealth election because of the need to allow the states to retain certain powers. We've got the acquisition by the Commonwealth of property on just terms. Now, why do I bring out that one? Well, actually, that's a good example of a constitutional power, constitutional right which has been written broad by the High Court. That is, the common law has looked at that right, and when the Constitution refers to property, the High Court has interpreted property pretty broadly. So it doesn't mean just land, it doesn't just mean intellectual property. It could be something as esoteric as a shows in action, a legal action that you've got going. So essentially it gives an example of the way that rights can be extended. And a good example of implied rights comes from Lang versus the Australian Broadcasting Corporation, where essentially the High Court has found, and by essentially by judge-made law created at least an implied right of freedom of political communication. But we don't live in a country that has many rights which are explicit and explicitly set out in a single document. So, vaccinations. If you have a child and you choose not to have your child vaccinated, you can read these fact sheet from the Department of Social Services. There is a general provision which is no jab, no pay. Essentially, you will not have access to certain of the family benefits that are available either as tax rebates or as social security payments if you do not have your child vaccinated. That's it. You can come up with a reason why not, and there are some good reasons why not. Your child is contraindicated with vaccinations. You can come up with religious reasons why not, but the form, which is downloaded through 3 separate links from this No Jabs, No Pay fact sheet, is a 3-page form, and it is non-trivial to complete, and you will need the support of the religious organisation of which you are a member. So essentially, if the religion of Rob First sadly can't necessarily prove that it should have no vaccination because you actually assume organised religion. It goes a bit further in New South Wales. Essentially, you have to show that vaccination when you enrol your child for primary school. Now, the consequences of not having a vaccination for primary school is that your child has the likelihood of being excluded at any point where there is a risk of an infection from any disease for which the child has no vaccination. That's at a state level. For childcare, 3 to 5 years old, where this is typically provided by private companies rather than the state, typically those private companies say no vaccination, no place. So why have I gone down this road? Why have I talked about vaccinations here? Well, basically the way that the Australian Commonwealth and at least one of the states works is to say kids have to be vaccinated. So any approach which says, oh, well, I as a service person shouldn't have to be vaccinated would probably need to look at vaccinations which go beyond the same sorts of vaccinations that are provided to children. There are specific issues here. So Japanese encephalitis, which is a particularly nasty vaccination, I'm pretty sure it was the one that was that Jai referred to earlier as the ship that was turned back. That's a little bit different. But in general, vaccinations for normal childhood illnesses are essentially mandatory. If you are a member of the military, to argue that you shouldn't have to have relatively common vaccinations might well be a difficult line to run. So Australia's military law, as I say, is somewhat different to the approach that's used in other countries. So the Defence Force Discipline Act of 1982 creates a special set of offences that can be committed by service personnel, whether they're in uniform or otherwise, that have a specific set of enforcement and punishment regimes associated. There's also general law applies to service personnel as well, so the two work together. This is the implementation of either the depersonalisation or the individualising issues that we that discussed earlier. Enforcement of this piece of legislation is by a service tribunal. We can call it a court-martial, we can call it a defence magistrate, but it's by a service tribunal. And the reason it's by a service tribunal is because the Australian Constitution provides that only courts that are established under the Constitution are courts. And this became quite an important issue when this piece of legislation, the Defence Force Discipline Act, was amended in 2008 to create the Australian Military Court. Essentially, the idea behind the Australian Military Court was great. It was trying to say, well, natural justice is going to be provided to service personnel if the person who is judging them is not their commanding officer. That is, if you take out line of command and have a separation to a separate arbitrator, that judicial official will probably give better justice to the service personnel who's breached some code than would be possible if it's the commanding officer who impliedly gave the order in the first place. That piece of legislative amendment was struck out by the High Court. So the High Court said, no, the Australian Military Court is not a relevant court under the Constitution, and because it's not a relevant court under the Constitution, it can't sit as a court. Now, the courts martial have been looked at by the High Court in earlier cases, essentially ones which argue that service tribunals can't act extraterritorially. That was a particular case of sexual assault by a member of the Royal Australian Navy, where they argued that, well, this legislation can't apply out of the country. It's found to apply. Other people have taken, other service personnel have taken cases to the High Court arguing that properly constituted courts martial were a breach of the Constitution, and the High Court has disagreed. The establishment of the Australian Military Court was a step too far. We've now got in place some essentially legislation which is designed to be provisional or temporary in 2009 and is still on foot, which allows for the actions of what would have been the Australian Military Court, but in compliance with the Constitution. And there have been at least 2 cases since then taken to the High Court arguing that this is this interim legislation is faulty, and both of those have failed. The cases are up on the conference website. In effect, despite all these issues about the Constitution, you still have to obey orders. So, what's an order? Well, an order is simply an order which is either, I've done it in the wrong order, it's either a general order or a command given to somebody by a superior officer. If you are a Defence Force personnel and you are under orders and you fail to carry out those orders, but not just fail, you've got to use your utmost exertions to carry those orders into effect, then you've committed an offence. And that offence is punishable by imprisonment for up to 15 years. So, typically, the sort of order that might say you have to have normal vaccinations will exclude the ones where there are known adverse side effects would likely fit into a general order rather than a specific. So, if there was an order, a general order, to have RFID devices inserted, would there be much of a claim to say, well, that breaches my rights? Well, I think there are two different sets of risks. I think there's a risk to the person, and the major risk to the person is likely to be the risk of anaphylaxis. Essentially, Kayla's, did you say you've got 9 piercings? 7. Each time you have a piercing, you have a slight risk of going into anaphylaxis. And each time I go and visit places in South Asia and have vaccinations, I have a slight risk of anaphylaxis from the vaccination, and as well as a separate risk that the vaccination might be problematic. This year, there's been a High Court case which found that in a very specific environment, but one which I think has some lessons, that a vaccination that caused ill effects, illness, and specifically illness, did not create a liability for the military under the Safety, Rehabilitation and Compensation Act. That is, that a vaccination causing an illness but not an injury means that there is no injury for the purposes of pensions, rehabilitation and compensation. So I think there are some arguments, strong arguments to say that if there was a military, a general order that said we're going to replace dog tags with RFID devices, it would be difficult for individual military personnel to say, I have a real problem with that. On the other hand, I think that from a military perspective, there's a real problem with it. And the problem is not people reading information. The problem is much more simple, and that is detecting that there are people that have RFID devices going past a particular point. So in effect, even though you would presumably choose to have RFID devices which are low frequency devices, the 130 odd kilohertz devices, rather than the VHF or UHF devices which can be read from a further distance away, that you would be able to detect that devices are there and that has the potential for forming a tripwire. In effect, the identification friend or foe could be particularly used by non-state actors in a military environment to detect the presence of military personnel, and that risk of itself may be too great. It's a bit harder to say, oh well, we can detect the difference between different forces. You can always say there are some people here. You could probably work out they are carrying weapons, because all you need to do is to have a loop in the ground to detect there is some steel passing this place. But to be able to detect that these are people who are passing this place, that are setting off essentially that there is steel passing this place, but also that they have RFIDs, leads to a different environment. That's it. Thank you.
Awesome. Thank you very much.